of really important issues on our agenda this morning, but before we begin, I'd like to do two things. First, I'd like to have the committee introduce themselves. So we'll start with Senator Sears, who is on Zoom. After we do our introductions, then I'd like to say a couple of words about our meeting and how we meet and what it means to have a quorum when we can vote and so on. So Senator Sears. Can you hear me, Senator?
Frozen. He looks frozen.
He's frozen. Okay, so we'll come back to him. Go ahead.
Representative Kelly Payala, representing Londonderry, Weston, Stratton, Jamaica, and Winhull.
Representative Ann Pugh, representing South Burlington.
Senator Ginny Lyons, representing Chittenden County.
Representative Kimberly Jessup, representing East Montpelier and Middlesex.
And in Bennington,
Senator Dick Sears, representing Bennington County.
all right, terrific. Thank you all for being here. Just a word, we do have one member missing this morning. And to say that the rules for our joint committees state that we must be present in order to contribute to the discussion or to vote. And in order for any voting to take place, we must have a quorum in the room. So at this point, we do have a quorum in the room. If we were going to do any voting today, we could do that. In terms of the ability to contribute, I'd like to say as chair's prerogative, I will allow for our senator who is on Zoom to contribute and to raise his hand or to let me know when he would like to speak. So there's no reason to exclude Senator Sears from the discussion.
Thank you.
Any other, and the last thing, of course, is for those of us in the room, we must wear masks. So everyone who's in the State House must wear a mask. Okay. And the other good thing is that now we can get booster shots. So that's a good thing. All right. So good morning, everyone. Today, we're going to be looking at the final Family First plan that the Department of Children and Families has put together. And we have Deputy Commissioner Erica Radke here with us to talk about that. And then a couple of also Judge Grierson to offer a comment, especially on specific areas of that plan. Before we dive into the plan itself, I'd like to ask Vice Chair Pugh, if you have any comments you would like to make. Your committee has done a great deal of work on Family First, I believe.
We have, and I just look forward to having a copy of the plan and hearing where we are right now.
All right. So Deputy Commissioner Radke, thank you for being here. I know it's a busy time for all of us, but we greatly appreciate it. So why don't you begin with your testimony? And I guess the question that Representative Pugh has asked is, do we have a copy of the plan at this point?
Actually, the plan is being finalized to be submitted today. There's some final edits being made, and then I'll be able to take a look at it and then forward it on to our commissioner to make his final approvals. And then we absolutely plan on having it go out today. So once it's been finalized, I'd be really happy to share it with you. But I know that Beth has, I believe, a meeting at 11 to go over some final suggestions and to input some edits. But after that, once Commissioner Brown gives its approval, we'll be ready to send it out.
All right. But you do have some comments to make on the plan itself, and we have a couple of documents from you. So why don't we turn it over to you and Beth? And Beth, I know you're not where it looks like you are. But wouldn't it be nice? So, okay, so go ahead.
Okay, great. I know Beth's going to help me with the slide deck. Thank you. So good morning, everyone. For the record, my name is Erica Radke, and I'm Deputy Commissioner of the Family Services Division of DCF. And I've been asked to testify about the Family First Prevention Services Act, also known as FFPSA. And our FFPSA lead, Beth Sawsville, is here as well. To the next slide. Specifically, I'll be discussing Vermont's prevention plan, which I'm happy to say, as we just discussed earlier, will be submitted today after final review by myself and Commissioner Brown. I'll also be talking about the requirements for the Qualified Residential Treatment Programs, better known as QRTPs, including the 30-day independent assessment requirement and program requirements. The plan itself that we're going to be submitting today has 5 key components. The first component is where we describe our vision for how FFPSA can be operationalized in Vermont. And I want you to know that this vision came out of close collaboration with our community partners. What we envision is that in the shorter term, we'll be working to create agreements with other agency partners to build upon the service array by including well-supported evidence-based programs currently offered by others, in addition to being able to include other EBPs as they make their way onto the clearinghouse as well supported. This recognizes that although good work is absolutely happening in so many programs in our state, we're not going to be able to draw down funding until these programs are on the clearinghouse. So in the long term, we hope that the funds will follow the child or the family with them as that the number of EBPs increases. Moving on to the next dot there is candidacy and evidence-based programs. As far as candidacy, we intentionally made our definition of candidacy really broad in order to allow us to determine and provide services to those most in need. And year 1, we'll be starting with motivational interviewing and parent-child interactive therapy as well-supported EBPs, both of which have had proven success here in Vermont. As far as workforce training and support, one of our first responsibilities is to be leaders in messaging and modeling FFPSA's forward-thinking approach to child welfare. But we do that while acknowledging and building upon the already existing practices, such as the work around placement with kin that fits so squarely within the FFPSA rubric. Our intention is to use FFPSA to enhance the work that we've already done, but in no way denigrate the work that has been going on for all of these years. We're looking at it to be collaborative and to work together. In terms of caseloads, we do continue to work on further lowering our caseload to family ratio, our caseworker to family ratio. But I found that it's really a moving target given the increasing complexity of the cases that we have and also the stress of the work, which does contribute to staff turnover. We are continuing to look for ways to attract the best candidates for this work while still retaining the employees that we currently have, all in an effort to achieve best practice outcomes. And finally, there's QA and data collection. Being able to effectively measure and report out on the best practices is critical to the success of FFPSA, which is why implementation of a CWIS system is so important to the division. Now, if you're wondering why the slide has an umbrella over all the components, that's to symbolize our commitment to improving our communication with the general public about what we do here at DCF. We're in the process of designing a communications plan that'll be woven into all facets of this work moving forward. And part of it is a very strong emphasis on bringing in family voices from those with lived experiences as well. It's been really such a big push to get our plan ready to be submitted to the Children's Bureau that's been where so much of our focus has been. But really, that's the first step of this process. Now our work groups and our teams are going to be pivoting in order to build our implementation infrastructure. And what that means is we'll be working towards the primary goal of ensuring that our workforce has the necessary tools to effectively meet the needs of the children and families that we serve through the rubric of FFPSA. So now I'd like to switch gears and talk about QRTP assessments and programming.
Can I ask a question about workforce?
Sure.
Go ahead, Senator.
Thank you.
Commissioner, I think it probably is best if we ask questions as we go along. And does that fit with your thinking or?
Oh, that's fine.
Okay.
I guess my question has to do with workforce development and training and the serious problem that we have in getting workers. I know there are a huge shortage throughout the system. And I'm wondering what is being done to raise salaries, to improve. I mean, it's tough work. We all admit that. We all know that. But are there things in this plan that will maybe entice people to come to work in this field?
I'll let Beth talk specifically to what's in the plan to entice workforce. But one thing we're doing in general is I've started a workforce development group within FSD, and we are looking internally as well as externally. Internally for ways to create that work-life balance and ways to retain the good workers that we have. And we've talked about bringing in speakers from other agencies that do similar kind of work where we notice their morale is pretty positive. And also some speakers from Connecticut. The deputy commissioner there is really dynamic and has been doing well. So we've got ideas around that. And in terms of externally, we do plan on reworking our interview manual, one that it does encompass other ideas that were made that have come in force since the manual was made in terms of equity and questions around implicit bias, but also just to make sure that we're all using the same manual with the same questions in order to really attract and suss out the type of people that are best suited to do this work. Beth, in terms of FFPSA, is there a specific workforce component you'd like to add?
Yeah, thank you for the question, Senator. I think that the essence of family first and prevention work is at the core of what brings our workforce to the field to begin with. I think the interaction, the engagement with children and families is what our workforce is skilled at and what they want to be doing. So I think that as we are able to shift more from intervention to prevention on some levels, I think that in and of itself will be an attractant to folks coming into the field. I also think that, you know, as Deputy Radke shared, I think the way that we communicate our work can also better describe and better bring people to the work in Vermont. I think that we're a very forward-thinking state, and I think that Part of it is the messaging that we send, both internally and externally.
Thank you. I didn't hear anything about salaries, and I think one of the problems in many of the, at least the contractors with the Department of DCF, and even with many of your own staff, is salaries are relatively low. And is there any move afoot to improve those?
All right, thank you, Senator. And I think Representative Pugh wanted to comment about.
Senator Sears, I could not agree with you more that salaries are an issue. I do not believe that that is part and parcel. And Beth, correct me if I'm wrong. I do not believe that that level, that is what the plan is supposed to be. Now, of course, we can't see the plan, but I do not believe that the components of what are to be part of this plan relate to salary, but rather they relate to larger issues. We need to deal with salary, but I'm not sure this is the place.
Well, let me ask another question then related. And this is for either Beth or the Deputy Commissioner. As we're talking about workforce, obviously there are some CME requirements that folks who are out there working have to maintain their credentials. So it would be helpful to know what, if any, changes you're recommending around credentialing or the continuing education required for folks who are working with our kids in various ways. So can you comment on that? Is that part of the workforce discussion in the plan? Deputy Commissioner, did you hear me? Or
Yes. I can talk generally in terms of, I know that there's a component of the plan that uses a QRTP regarding motivational interviewing. And we will be, we have received monies to do motivational interviewing training for several members of our staff. And then also outside of the plan, we are doing training in preventative and restorative justice through part with the University of Vermont Law School as well. And that's not specifically in the plan, but I believe that restorative justice piece in terms of bringing families back together to make a restoration for families that have been harmed still fits in well with the primary goal of Family First. Beth, do you have anything to add?
Yeah, what I would say as well is that what I didn't mention a few minutes ago is that we've also been in an ongoing way and myself kind of personally involved with the National Child Welfare Workforce Institute. And that's all about
Beth, I don't want to interrupt, but I'm having a difficult time understanding everything you're saying. The sound is being distorted. So, but go ahead. It's probably my ears. Go ahead. No, it's not my ears. Okay, it's everybody's ears. If there's a way to speak into the microphone or have a headset on, that might help.
Is that better?
Yes, ma'am.
Oh, perfect. So what I wanted to say is that we are also, the workforce development piece of the prevention plan is really the most ongoing. I mean, several elements are ongoing and will kind of roll out. But workforce development really, as it related to Family First, really required the other components of the plan to be solidified for us to then figure out the communication and the messaging and the training and support that needed to go along with that rolling forward. So much of that work will launch into high gear from this, from this point forward, and even more so as our plan gets approved. In addition to that, we are connected with the National Child Welfare Work, been personally connected with that group for a number of years now as a representative of Vermont, with the University of Vermont representation, to look at child welfare workforce and retention, recruitment and retention. So that is absolutely at our forefront, and we recognize the incredible need that we have around that. I don't have anything to comment, Senator, around your comment around pay. I think that, anecdotally, having been with the department for the last almost 3 decades, I think the work has become a lot more challenging, which has increased the level of stress that our workforce faces. And but I don't know that I don't have anything to add around the salary and piece of that.
Beth, is it naive of me to think that this is something that you hadn't thought about and that will be maybe put into the plan before you send it, or will be something that you will affirmatively look to address when you talk about updating and revising the plan?
Yeah, I'm happy to take a look at it through that lens. We certainly have had workforce development at the forefront throughout all phases of this process, kind of concurrently. But in terms of the language of making sure that that's specifically woven into the plan, I will take another glance at that. What I can tell you is in the caseload section, that absolutely speaks to the discrepancy between what exists currently in terms of caseloads and what would be ideal, and that gap being specifically attributed to social worker retention.
Okay, thank you. Why don't we let you continue with your presentation?
Thank you. I mean, those are great questions too. And I do want to acknowledge that a lot of times we do talk about the rate of pay for our social workers. It's just that at this point, I don't, I'm not in any position to say that we are, what we're up to at this point, but it is absolutely something on our minds. As far as the independent assessments, the slide here I have might be a little bit of a review, but I just wanted to talk about, why do we need an independent 30-day assessment? And so the FFPSA adds requirements on the state of Vermont to continue to draw down Title IV funds for residential treatment of children in DCF custody. So beginning November 1st, today, Title IV drawdown for congregate care placements is only going to be allowed when a child or youth has needs that cannot be met in any other community setting. And so in order to establish that appropriate level of care for the child, an independent evaluation must be made regarding the level of placement. And this assessment must be made within 30 days of the congregate care placement. So the FFPSA team quickly mobilized to get the independent assessment piece in place. We issued an RFP several months ago, identified a successful bidder, and now we're currently in the final stages of negotiating a contract with that bidder. And so this slide shows the best practice timeline for placement assessments. So this would be in the best case.
I need to clarify. I just need to clarify. So what you're saying is that the independent assessment is being contracted to a separate entity.
Yes.
Not DCF. And so, is there a contract or an MOU for that? Will we be able to look at what is included in that relationship?
Yes, the contract is in the final stages of being negotiated. We were hoping to have it done this week. But yeah, there is a bidder that we've selected that had a lot of experience in other states doing these types of independent assessments. And they had a really great framework for getting them done well, but quickly. And that was something that was important to us, that the substance was there, but that they would also have the infrastructure to handle the number of assessments that we were anticipating that we would need them for.
So that was my next question, actually. And how many assessments are done on a regular basis for the 30-day period? I'm just trying to figure out what the capacity is, within DCF to carry out the assessment, but now you've indicated that it sounds like there's not that capacity. So can you talk a little bit about the sort of the caseload, what's involved for each case review, and how many are there currently?
We're anticipating for the FFPSA 30-day assessments, there will be roughly 300 that will occur in a year, because a child would need an assessment for each placement, and sometimes a child might be placed twice in 2 different facilities. And in terms of, we wouldn't have the bandwidth necessarily to do the assessments, but I believe our council and looked at the regulations, and it was determined that really it should be an independent assessment as an outside of our agency to be the one doing the assessments. In terms of the actual steps of the assessments, I defer to Beth to sort of walk us through that.
So the contract that you're finalizing at this point with an outside organization, do we have the budget to cover that? Was that anticipated in the development of the plan?
Yes, it was. And I do want to confirm too that DCF, per the regulations, we would not be allowed to actually do these independent assessments, which was another reason why the money had to be built in to address that piece.
Okay, so the requirement is that DCF cannot do the assessment because it involves some assessment of DCF participation.
Exactly.
Yeah, okay, that helps. That's kind of the bottom line, it would seem. Okay, go right ahead, Deputy Commissioner, please.
Oh, and also I should point out too that these assessments will have a payment through Medicaid and 4E as well. Beth, did you want to sort of talk through the assessment process?
I have a question. The assessments will be paid for by Medicaid as opposed to any of the Family First federal money?
I believe there's some 4E component as well as Medicaid. Is that correct, Beth?
That's correct.
Can you clarify? I didn't hear the comment at the end, Beth. I didn't hear what you said.
I just said that's correct. Title 4E is the payer of last resort, but Medicaid is able to cover that cost whenever a child or youth is Medicaid eligible. And so we have developed, the business office along with us have developed a formula for assessing kind of where that draw will happen for each assessment.
So Medicaid is a payment of last resort. Your sound is going out. That's okay. So the Medicaid payment is kind of the backup.
The Title 4E is the backup.
Title 14 being?
Title 4E. 4E.
Oh, thank you. That's how bad my E. Okay, Title 4E is, I got it. All right, thank you.
Okay. So this slide here, as I was saying, it just shows the best practice timeline in terms of placement assessments. It's aspirational. So in this best case scenario, the entire process would take no longer than 40 days. So I'm just going through the chart here. On day one, an FSW would identify a child needing a higher level of care. And as soon as day 2 or 3, the child would be referred for an independent assessment, which would come back sometime between days 14 and 21 and would be submitted for case review. And within a week or so, all the reviews would take place. And by day 40 at the latest, the youth would be placed and able to fully engage in services. And it would be just such a wonderful thing to be able to have a child that has that particular need. We need to do the assessment, but to get everything done so effectively and efficiently so that the child doesn't have to suffer a delay to get the support and services that they need.
Deputy Commissioner, you said the timelines were aspirational.
Yes, this is the best practice.
I thought the timelines were in statute.
I guess I should say this is the best practice when everything is working perfectly. And as we know, we're dealing with humans, so sometimes things are going to be delayed.
Okay, I guess I'm just trying to clarify my understanding, which is best practice and aspirational are what is in the statute. Is that correct?
I wouldn't say I would say aspirational isn't in the statute, but yes, this is the best practice, and that would be statutory.
So these timeframes are statutory, are legal timeframes.
No,
At least
so
the ones in terms of the assessments. Beth?
would you like me, I could clarify if you'd like. So in the Family First legislation, it really has the outside set in stone timeframes as post-placement timeframes. And what we have been talking about and put in our contract in our RFP language is that our preference is to have both of the statutory timelines happen far sooner than what is in statute, with those being kind of the last resort. So the timelines that are in statute are 30 days post-placement for the assessment and 60 days post-placement for the judicial review. We have backed that up in our timeline to align with what we think would be ideal for the child or youth. Hopefully that clarifies.
So as you are finalizing the contract with the outside organization doing the assessments, do they agree with their ability to complete the reviews as you have indicated, the best practice?
Yes, they do.
Okay, and who's going to oversee that? Who's going to oversee the overseers?
We have our clinical director, Jennifer Herbert, and she would be the one monitoring the independent assessments. And I should thank you, Beth, for that clarification. So really, as you did say, this is aspirational and best practice, and apparently the regulations are broader and give more room.
Okay. Let's keep our fingers crossed then. We want that to be the case.
Yeah. Can I ask one question about this timeline?
Sure, go ahead, Senator.
If a child has allegedly committed a fairly serious crime, does the timeline fit if the child is placed, say, at a congregate setting on detention? I'm thinking the depot programs, or for girls, the the Beckett programs or even Sununu. Will those timelines be required while the court is going through its process of making findings and so forth?
No, Senator. So your detention programs sit outside of the whole qualified residential treatment program process, as probably as your short-term stabilization programs would as well.
Okay, thank you. That's helpful.
Okay, go right ahead.
Let's move on to the next slide. So DCF is focused on providing high quality trauma-informed specialized residential care in Vermont. And we've been working really closely with the residential treatment programs regarding the QRTP requirements of FFPSA. But we recognize that this is not an overnight process for most of the programs to meet these requirements, and that it's really going to be an ongoing work in progress. So we'll be working with all these programs to figure out how to braid them into our overall system of care through the QRTP system or by serving as a carve-out population. And this is because we value our in-state programs and their commitment to the treatment of our most vulnerable children and youth. So I want to just talk a little bit about our core mission at DCF. And as you know, our core mission is to keep children and youth safe. And we really look at the FFPSA as a way of enhancing our best practices and as a possible avenue for additional funding in support of our mission. We're really excited about the FFPSA and the changes that it could bring to the system of child welfare as we know it. So are there any questions?
Yes, I'm sure there are. I'm gonna start with a question about and a comment. First of all, when will we be able to see the final plan? I know you're finishing it up and wanting to get it submitted today. Well, I think that's a requirement. So
Yes.
when can this Oversight Committee have a copy of the plan sent to us?
I would not see any issues with sending you a copy of the plan once we get it out of the door, sending it to the Children's Bureau.
All right.
It's really great work, and I've seen various iterations of it, and I'm really proud of the plan.
Well, that's good to hear. And I know that you've been working extremely hard on this. I will share with you, I think from the committee that we have a level of frustration in not being able to review the plan before it's being submitted. But we do appreciate the work load that you all have been under. We understand that. But as soon as we can see the plan, that would be helpful. And then related to that question is, once the plan is submitted, you probably will be getting comments back about modifications to the plan. And it may be at that point that this group would like to weigh in on what's included in the plan. So that's just a kind of the heads up, and yeah, it gets really complicated when it's in the middle of a democracy, but just our thoughts on that.
Understood, and we would welcome that input. And in terms of a document going through a democracy, that is definitely what we're suffering right now. But I'm just glad we're going to be able to get it in on time. And we look forward to, during the revision process, going back and forth, you're having additional input from the committee.
Well, that's good. And so what we will probably see on our next agenda is an opportunity for us to have that discussion. So, yes.
Great.
I don't know what the timing is for feedback to you from the federal government. Is there any, do you have a sense of when they'll give you information back about the plan?
Well, I know it takes 6 to 9 months generally to get one approved, and it's my understanding we should be hearing at least one first salvo of communication and feedback within the first couple of months. Is that fair to say, Beth?
Yes, I think that's accurate.
Okay, well, so we'll keep our fingers crossed that while we're still meeting this fall, we'll be able to process that information. Then I did have another question and it just went out of my head, but I know it will be coming back. I'm going to ask committee members if they have any questions for Beth or Deputy Commissioner Radke.
I guess I just want to thank you all. I know you're working under immense pressure with not enough staff. And I want to reinforce what the chair said, which is we're going to want to see and discuss the plan. I was under the potential misremembering that in fact we had put somewhere in some language somewhere that this committee or the legislature would receive a copy before to comment. We haven't been able to find that, so this may have been wishful thinking on my part. I have reviewed in the past the material from Casey, who was working with you, and one of the pieces in there says that a plan is better if we work collaboratively with input from the legislature. And with all these reporting have been very helpful and informative, but those are reportings. Those are not working collaboratively. And I look forward to, in the future, us working collaboratively as opposed to you working solo without the benefit of our support.
I appreciate those comments and I understand, and I am glad that with this particular process with FFPSA, since we know that there's going to be a back and forth, that you'll have an opportunity to have that input, which I really welcome.
Good. I guess I did remember my other question, and that was during the current process, what type of outreach did you have with various stakeholders to give input to this? I mean, we weren't part of that process, but obviously there are others out in the state who probably were. So can you talk a little bit about the engagement process that you had as you developed the plan?
Absolutely. We've had that huge workforce, that work group that had at least 80 people in it and included community members as well as members within our division. And I know that the survivors from the St. Joseph Orphanage were part of the group and added a lot of valuable input to the plan, and we continue to work with them as well. I remember that there were other community partners like Child Prevention Vermont that were part of our work group. Beth, who else did we have involved?
Yeah, we had, that's accurate. Looks like I froze for a moment. That's accurate. We had several other departments and divisions, as well as family serving organizations. Many of those organizations were able to reach out to families and youth to gain perspective and input for the various pieces of our plan as well. And many of those folks will continue ongoing in our implementation work forward. I would also re-extend the offer to any or all of you that we've made in the past around your ongoing participation in any of those work groups, that you're always welcome.
All right, thank you very much. Yes, I know that you mentioned the work group and the 80 folks at our last meeting, but I wanted to raise that again. So there has been some community support and input for the plan that you're putting forward. But we're legislators and we feel a significant responsibility for being engaged and involved. And I am smiling while I speak. So thank you for that. Any other questions for the folks from DCF? All right, that's very good. Thank you. And if you don't mind just staying with us while we hear from Judge Grierson on the assessment piece and the 60-day period, because I think that's probably an area of concern going forward. And I know that Senator Sears had asked the question last time about, do we have the staff and the capacity to complete the work within the judiciary? So Judge Grierson, welcome. And we're happy to hear your thoughts.
Thank you, Representative Lyons, and thank you to the committee for inviting me.
Excuse me, you just promoted me to representative, but I am a senator.
Well, you see, that's why it's time for me to leave. If I'm still making that mistake. I apologize, Senator. You're now back in your proper, you're back in your proper place.
It happens all the time. Thank you.
I apologize for that. For the record, Brian Grierson, Chief Superior Judge, and I want to thank the committee and the chairs for inviting me to testify to this. And I think the questions raised by Senator Sears are obviously the questions that concern the judiciary. We certainly recognize the benefit that this legislation, the Family First initiative, can bring to the families that are impacted and that come before the courts. I have been talking with Ms. Radke for a significant period of time about the impact that this program will have on the courts, and I share the concerns of Senator Sears and others, and I've shared those with Erica. My concern is that obviously the 60-day review, at least from my discussions with DCF, that's where the court will come into play. The chart that you saw a few minutes ago that lays out the timeline for the assessment and so forth, I had not seen that chart before, and I was intrigued by if I was reading it correctly, that they marked the 60-day judicial assessment, if you will, and I'm assuming that's when you were saying the 60 days would start. But according to that chart, that could predate the time the child is actually in the placement. And that's, I guess that's concerning to me from this perspective. I understand the timelines are extremely tight. That the court not only schedule, but conduct that review and issue a decision affirming the need to continue that placement within 60 days. It can't be the 61st day, I'm told. It has to be done within the 60 days. And what concerns me is that I would think, and as I understood a reading of the legislation, that the 60 days starts when the child is in placement, not when you have made the assessment that they're entitled to or they should be in placement. And so I want to make sure that the 60 days starts when the child is actually placed, because otherwise, if we start it before then, by the time it comes in for review, there would be a limited period of time that the court would actually be reviewing placement and the child's performance in placement. So I understand this is a new process. But I just want to make sure that for the court to, there's no question that this is going to impose a new procedure on the court. I've solicited input from the judges sitting in the juvenile dockets. They recognize the need for these types of evaluations, but I think we're all concerned about the impact of adding another procedure to the court process. We all know that we are just barely coming out of a pandemic that has had a significant impact on our caseload and in our operations. This will add another dimension to it. And the process is new to everyone. So I expect there will be some issues adjusting to this new process. But I think it's important to say that we have concerns, but we're prepared to do what we have to make this work and meet that 60-day deadline. I have talked with folks in trial court operations. And again, we understand the potential impact on the courts by adding this process. We generally schedule 2 months out in a docket like this. And so in that sense, 60 days is something that is consistent with our current scheduling practices. So I'm not concerned about that, but getting that notice that the child is now in placement, that will trigger the 60 days from the court's perspective. It is difficult at this point because it is a new process to really understand how much time needs to be allotted for these hearings. I know that the information I have is there could be anywhere between 300 and 350 placements. So obviously, being a new process, it's going to be new to us to adjust to how much time to allot for these. And so we have concerns, but we're ready to do our part.
Okay, so you just raised a significant number of questions for me. And I see Senator Sears also has questions. But let me ask this first, and then Senator Sears, I'll let you just take over on this one. But
no.
My question is about the chart, the little chart that you were talking about, Judge Grierson, and it might be helpful after Senator Sears asks his question, if we can put that up again and try to understand the juxtaposition of what is happening by the independent assessor and then what responsibilities are left to the court and how those flow together. So that I'm going to ask that we do that, but first let me turn to Senator Sears.
I guess I wanted to get the judge's comments as well as DCF's comments. When it's sometimes, and I've been to reviews 6 month and 6 month and yearly reviews on kids in placement. And most of the time they're fairly routine. It takes 15, 20 minutes because everybody agrees. But when everybody doesn't agree, when the child's attorney or the child's parents or whomever, or even the state's attorney is objecting to whatever the plan is, that's when it can take considerable time. And that's given, we've getting through this pandemic and the pressure on the judiciary is immense, as most of you know. And I guess my question for the judge or for the deputy commissioner or for Beth Sosville is, can we do this when there is a challenge? How is that going to be handled? Sometimes it may require coming back 2 or 3 times just to get a settlement of the issue.
And Senator, I couldn't agree with you more, and that's this discussion I've been having with the department. Because this is a new process, I agree with you that there may be many of these cases that will be essentially uncontested. And folks will agree that this placement is appropriate for the child and should continue. And those are the ones that are going to be scheduled for or will not take much time. Our concern is in looking out 60 days from that placement. We're not going to set aside a large block of time for these cases. We can't under the present circumstances. So I would expect that we will set a time, a relatively short time, and it'll have to be less than 60 days in order to make that assessment. Is this a case that needs hearing time? How much hearing time? And so that's why I'm concerned that once you make that determination, then it's a matter of finding time in the schedule. And it's then, of course, finding the time within that 60-day time period. And I have this is going to be a struggle. I'm obviously the more cases where parties agree, then those aren't going to be the problems. There may be some cases that are going to slip by that 60-day mark. And I don't think anyone involved in this process can consider anything other than the fact that some cases are not going to make that final 60-day mark with a decision, a hearing, and a decision. I think that's the reality of the process.
Well, I would also add, and it does make sense to me. I can understand the concern looking at this as a judge and not being 100% clear about how many cases are going to have to be absorbed in the system. But in addition to the cases that won't take a lot of time because there'll be agreement, there also will be a number of cases that are simply record reviews where they can go through the system very quickly because there won't be the need to have a contested hearing about those cases. So that too should alleviate some of the pressure on the court and leave room for those cases that are going to be, more of a drawn out process.
And I understand that. And I would, the only caveat I would say, Ms. Radke, is that we still have to schedule, once they go in placement, without knowing whether it's going to be a record review or a contested hearing. So that's part of it.
Understood.
Sometimes it would seem to me that there are times, regardless of how quickly some cases are resolved, there are going to be times when a case is going to drag out because of the nature of the case itself. And I guess a question I would have is what latitude is given at the federal level? What's in the law that allows for that to happen, if anything?
That was my exact question. And the information I received was that it's hard and fast. If we don't get that hearing in and a decision out by the 60th day, the placement can continue. But DCF will not get funding for any decisions beyond the 60 days, or they won't get reimbursed, I should put it that way. The 4E funds.
So now if there's let me ask this of the commissioner, deputy commissioner, if there is some kind of a holdup by the external assessment folks, and that results in the prolongation to beyond the 60 days, is there anything in the contract that allows withholding funds from the group paying them for the work that they haven't done?
I have not looked at the language of the contract itself. It's with our AAG, but that's an excellent question and an excellent term that, seeing that we're still in negotiation, I'm going to talk about adding in, because you're right. This process has so many moving pieces, but in whatever small areas where we have influence, in order to push that lever to make sure that we are moving along as quickly, yet of course making sure the children are best supported, but being efficient and effective, we're going to do to make sure that we can move this forward.
Okay. Any other questions, Representative Pugh? I could say Senator Pugh.
Oh, excuse me. Actually, I just I received a message here that that is already in the contract, not paying for assessments past 30 days. So they've
Okay,
already,
that's
I
helpful.
guess,
Thank
good
you.
minds think alike. You're on the right path there.
Okay, terrific. That's very good to hear. Thank you.
Deputy Commissioner, and I apologize, I may be going back to, I think I missed something. And if I'm going into the weeds, tell me I'm going into the weeds. So we're in the process of contracting with an entity that are not state employees to assess families. Really?
That is correct.
So what's going to be the job of the DCF employees, the family service employees?
Well, one thing, these whole packets and all that information still does need to be compiled. And remember, the family services worker is the first one that makes contact with the youth that we feel may have those
They're
heightened
not
needs.
going to be doing the assessment.
No, they're going to be identifying individuals that they believe may have those particular high-end needs and then moving them on to assessment. But Beth has
So
some
how many
additional.
other, so I'm sorry, that is interesting. That is a big change that may or may not be a good change. I'm not saying it's not, but that's basically taking what has been a state function and contracting it out.
I think the assessment is only a small part of the whole of getting to know the child and getting to know the child's needs. And all of that type of work still goes on at DCF before they get to the level of, oh, I believe this young person needs to have an assessment. So the assessment itself is grafted onto our additional work in supporting the children and making sure they have what they need. Beth, did you have anything to add?
Yes, I was just going to add a couple of little things, which is number one, to keep in mind that the assessment is narrowly focused on the clinical level of care needs of the child or youth, number one, and making recommendations around that. They do interview involved family, as well as fictive kin in their process. They're utilizing the child and needs and strengths survey, child and adolescent needs and strengths survey to make that determination, and then making treatment service recommendations, kind of case planning recommendations out of that. But the worker prior to that is, doing everything that they're already doing. And keep in mind that from time to time, in special circumstances, we are already referring children or youth out for assessments or evaluations in cases that is above our level of expertise. So this piece sitting outside of our system will only help to inform both the worker and the potential program about directionality of treatment needs from a clinical lens.
I look forward to reading the plan, and since we don't have the plan, I can't comment, but this looks like taking away a function that DCF workers have been doing, are being trained and educated to do, and they are in charge of the assessment, whether or not someone else, they're in charge of writing the case plan. They are in charge of referring out if there needs to be a more specialized assessment. What I am understanding you all to say is that lockstep, someone else is going to be making those final decisions. I may be mishearing you and misunderstanding, but that's a function of not having had the opportunity to read the plan.
So let me ask this question, because this was these were the questions that I was asking earlier. And I think you said earlier that it's a federal requirement that external assessment take place. True or false? Is that accurate?
Yes.
No, so wait, but I think what Representative Pugh is bringing up is that one size shouldn't fit all. I mean, our state, it may be significantly different, from any other state across the country, which obviously it is, we're unique, but if this is a federal requirement and then they're putting the timeline on it, all the money that we're getting to support the assessment is coming from federal government, but with a backup plan for state-supported funding. How is all that? I'm just as concerned as Representative Pugh about contracting out work that our DCF folks are doing. It seems really problematic. And then it puts an extra burden on the judiciary to meet a timeline that's externally applied by either the federal government or an outside agency because they can or cannot meet the timeline. So it gets a little bit confusing, I have to say.
Well, I just want to make sure to address in terms of our workforce, and I mean, they are already super, super busy. And this particular assessment, really, it's after all of the work that's been done by the social worker to flag that this child may need additional services. So that work is still going on in-house. And also, we're really put in a situation now with the federal requirement that in order to get the Title IV funding that we need, they've made these changes in terms of payment. So it's important to us to try to put all these different pieces in place to make sure that we can still get those $40.
Okay. This will be interesting to see how it plays out, but it will also be extremely helpful to see the plan. And go ahead, Representative Jessup.
Yes, thank you, Chair Lyons. A question I have for Judge Grierson is, I appreciate your candor in raising some of the concerns regarding the judiciary. And my question is, what sorts of cases and work within the juvenile docket will be displaced potentially by this additional, I'm looking for a, not burden, but additional workload?
I can't say that anything will be displaced. I mean, it's a matter of scheduling another proceeding to be scheduled. And the difficulty is, as I said earlier, that we have a significant caseload already. I'm concerned about the timelines, and I have conveyed that to DCF. And I guess what might help folks to understand is that, for instance, in many of our courts in the juvenile docket, we have, let's say, an afternoon schedule, and there's a certain number of cases that are scheduled for different types of hearings throughout the afternoon. Many of the courts, the larger courts, will have a block of time, for instance, at 1 o'clock. Sometimes it's a half hour, sometimes it's an hour. It's called an emergency block. For those types of proceedings that we can't anticipate, but maybe a child was taken into custody the night before and we need to have that temporary care hearing within 72 hours. In other words, we leave blocks of time for emergencies. I will tell you that some days, the number of emergencies that come in almost consume the afternoon schedule before we can get to the matters that are already scheduled. And so in that sense, hearings are, I suppose, displaced or have to be continued for any number of reasons now. And we all have timelines that we strive to meet. This one is different in the sense that if this one doesn't get in, there's apparently an immediate consequence to DCF. And if this is scheduled, as I said, 2 months out, and it's put into, let's say, that emergency block, and there are any number of emergencies that come in the meantime, this case may not get the attention it needs then. And then the more important question is, how quickly can we get that before the court again and still meet that 60-day deadline? And those are the concerns that I have. So I wouldn't want the committee to think that if this procedure goes ahead, that something else will not be heard. It's all a matter of timing and scheduling. That's something that may have to be continued to allow the time to get this in to that 60-day requirement. And that's quite frankly the concern we have.
Well,
Hopefully that
Okay.
answers the question, or maybe it does not.
does that answer your question, Representative?
Yeah, I just, I worry at the risk of sounding like a pessimist that we're just setting ourselves up for great difficulty ahead. And as we sit here on October 1st, what might we do about it? What alternatives might we not be thinking of, or should we be thinking of? I don't pretend to have any particular expertise, but I am concerned.
So one of the things that Ms. Radke mentioned, and one of the things I've been discussing, is what we don't know is how many of these matters will be agreed upon. In other words, it's hard to know how many of these will actually be contested. It's the contested hearings that I'm concerned about. We just have no way of knowing because this is a new process. And I understand the ability to have a record review. I will tell you my concern with record review is what volume of records will we be asked to review in order to pass judgment on it? And again, that's an unknown. I will tell you that if the records, even if it's an agreed upon resolution based on a record review so that we don't need a contested hearing, depending on the volume of records that the court has to assess to make that determination that the placement should continue, is likewise a concern. So somehow these cases have to come into the court, not at the 60-day mark. They have to come in before that with sufficient time to either determine whether it's a record review, do the record review, or set it for a contested hearing. And that's really what we're looking at.
But while you're speaking, I'm thinking about the other complication of if the external assessment disagrees with the assessment made by DCF workers, family service workers, and if there's a disagreement about how the case should be handled. So I can, there are a lot of little places where timing could be, timing and also costs, financial costs could be messed up, to use a very technical term.
And that's why my concern was in seeing that chart that you cannot start the timeline for judicial review until that child is in placement, as opposed to assessment.
Can I suggest that for a future agenda, and I'm going to miss Judge Grierson when he retires, by the way. But before he retires, if we could get him, once the report is out, and the Deputy Commissioner and Beth Sosvelt really discuss these issues. I see this as a major roadblock, and you're going to have this private provider providing the review, as I understand it. So, or the whatever you call it. And having personally been in meetings where we spent 45 minutes deciding whether I could be in the courtroom or not, as one debated and the other, I can remember, I won't get into all of that, but the judge knows that sometimes lawyers can take forever trying to decide if I'm the fox guarding the hen house or not. And that's just one example. It was 45 minutes. We were just arguing over whether I could be there.
Okay, I think we probably discussed this.
Senator,
Yeah, oh, I'm sorry, Representative.
Well, my suggestion is that we come back to this at a future meeting.
Yes, I think we did indicate earlier that we would do that, but this is really a strong area of concern, so we'll definitely come back to this specific issue, absolutely. And we'll do that either at our next meeting or the following meeting.
Beth had written something in the chat and it popped up and then went away, and I just was hoping to hear her say what she had written in the.
Oh, I don't have a chat.
Well, right, that's why.
Okay.
So sorry. What I was saying is that per the legislation, if the independent assessment does not warrant a QRTP level of care, then there is no required hearing.
Okay,
And I'm glad to work with Ms. Sawsville once that report's out to discuss these issues further.
I think that would be really helpful for us to know that you folks are collaborating and working on the issue so that we don't run into a train wreck along the way. Thank you.
I'd like to say too, I do look forward to those conversations, and I appreciate the judge, not only for his candor, but for his mentioning that this is a process where we're not going to know how many are going to need such an assessment where it's going to be a contested hearing until we get into it. So it's one of those things where we need to try to gather as much information, but we're really not going to know until we're there. And I appreciate his saying that.
All right, terrific.
I might also suggest that Judge Grierson not be allowed to retire until we get this to a well-oiled machine kind of moment.
Yeah, let me get back to you on that.
Wait, when is your retirement, Judge?
November 1st is the date.
Oh, no. Well, our next meeting is October 29th.
I'm still on the I'm still on the clock.
Okay, good.
I'll be there.
No pressure, but you now have a 30-day timeline, right? All right, I think that we have discussed this sufficiently to recognize a need to come back to it. Senator Sears, we completely agree with you on that. And as we go through the plan, as soon as we get it, I'm going to ask committee members to take some time and go through the plan and jot down the things that you would like to have us review at our next meeting. And we'll see and then we'll invite Deputy Commissioner Radke and Judge Grierson back in, and we'll see where we go there. But may require Beth and Erica Radke and others, so we'll keep our options open at this point. So thank you.
I would ask the committee to include Judge Zone, who will be my successor in this position to that meeting, and he can help with the transition.
That would be very helpful, and maybe you could just send Peggy her contact information.
Yes.
I have it. You have it. Okay, perfect. Okay, great. All right, well, then I'd like to move us along in the agenda. We're just a little bit behind on hearing the Chin's report, but before we do that, I would like to thank you, Deputy Commissioner and Beth, for the time that you have spent with us, but more importantly, with the time that you've spent putting the Family First report and plan together. And we look forward to being able to see that. Thank you.
Thank you very much for your time today. And we'll get that report to you as soon as we can.
Terrific. That's terrific. All right. Judge Grierson, you are here with us, and we have on our webpage the CHIN's case processing in Vermont. Is that a final report? Maybe we could just turn it over to you at this point.
Sure. Thank you very much. Again, for the record on this matter, Brian Grierson, Chief Superior Judge. Yes, the report you have in hand, it should be dated May 2021, is considered a final report. And it's obviously a very lengthy report. And I hope the committee members have had a chance to go through it. I know when it first came out, I went through it piecemeal. I continue to read it, and as I reread it, I find any number of matters that involve the CHIN's process. For just by way of background for committee members that may not be familiar with it, the CHIN's reform group began, I forgot now whether it's 3 or 4 years ago, but it really was, the idea behind it came principally from Senator Sears and Senator Kitchell late in the session. Invited myself, Ken Schatz, then Commissioner, John Campbell for the State's Attorney's Executive Director, and Marshall Paul from the Defender's Office, with the idea that there was some money available, funds available. I believe it was a tobacco settlement, and to set aside funds to take a broad look at the current CHIN's system and make suggestions for reforming or making changes to improve the process. I think at the time, it certainly was a product of the pressures the system was feeling from the opiate epidemic, which, as all of you know, doubled the cases coming through our process, and really were driving not only the volume of cases, but the types of cases we were seeing, and changing really the population of those coming into court, meaning that historically we were dealing with older children. The opiate epidemic reframed that population so that primarily the cases we were dealing with, or at least the new filings, the impact was on children 0 to 5. And I think that was the impetus behind this idea. And we put together a report, made certain recommendations to the legislature, not all of which were adopted at the time, but a number of steps were taken, including this report that's in front of you. That was a request from the CHIN's Reform Group to conduct this type of evaluation overview. It also included in other parts of CHIN's reform that the legislature approved, the hiring of a judicial master in the judiciary along with support staff. And that is a pilot that is currently underway, serving Chittenden and Franklin counties. And I'll be glad to talk about that in more detail if you wish. In addition, there was a early study to look at essentially a pre-petition activity to try to be in contact, connect with families to avoid their coming into court. So that's also part of the CHIN's reform. And the final piece that was approved most recently is initiative around mediation in the CHIN's docket. And that is the focus of the CHIN's group right now. Our more immediate focus is starting discussions around mediation. And we're inviting in folks from Arizona who have had years and years of experience with mediation in that docket and have had tremendous success. So this report, as I said, is just one piece of the CHIN's reform. It was part of our original recommendation. There are other recommendations in there the legislature has not seen fit to approve. Don't be surprised if whether it's me or someone else from the group comes back to the next session to explore some of those projects that were part of the initial report. And I should add, I know that Commissioner Brown is also on the agenda today, but I would suggest that you also get Marshall Paul and Evan Meenan to comment on this report too. I know that many, if not all of you, have seen reports, evaluations of this kind over your years with the legislature. There are some recommendations in here that I know all of you have seen before. The issue, one of the predominant issues in this report is looking at representation, and the different terminology is used. I think they talk about support high quality legal representation for parents and children and other references to it. I'm aware of at least 2 other reports over the last 10 or 15 years that make similar recommendations around that area and looking at the issue of representation of children and families. What struck me about this report, quite frankly, was how comprehensive it was. The more you go through this report, it touches on every aspect of the CHIN's docket. And by that, I mean, it talks about the judiciary, the role of the judiciary, what steps the judiciary could take to improve performance, either by training or procedurally. It talks about, obviously, the role of the attorneys, the relationship between the attorneys, clients, how some of the folks who come into court, their perception of not only their representation, but their perception of the court. There's a discussion in here about the pressures on guardian ad litem, the number of cases they have to take. All of these issues I know are familiar to members of this committee. But for me, this report seems to touches all of us who are involved in this process and makes recommendations as to how we can build on this. And I think what's also interesting from my perspective, from the judiciary's perspective, is that many of these recommendations are already at least somewhere in the works. This report can build on initiatives that are already before the legislature. I know that there are at least 2 bills, one on the Senate side, one on the House side. And I believe the Vermont representation, I forget their exact title, has proposed legislation. The bills that I've seen, I do not believe they received any hearings in the last session, but one on each side that calls for a more comprehensive study of this issue of representation of children and parents. And I think with that legislation and the recommendations and suggestions in this report, that could be a starting point to explore that issue more. One of the other items in the report speaks about, in looking at, for instance, the executive summary on page 2, it talks about leveraging Title IV funds for support of high quality representation. And I know from a meeting last week where Marshall, it may have been earlier this week, kind of lose track of time sometimes, talking about the 4E. And I know that the Defender's Office has been working with DCF, and I certainly don't have the information to tell you where that stands, but my impression was they've run into a roadblock on that 4E funding. And I think, again, Commissioner Brown may have certainly more information on that exact status, but it is something that is being explored, has been explored. I'm just not sure where that stands. Following 4E funding, which could be a significant factor in this review, if you will, of representation of parents and children. It also talks in other parts of this report about prioritizing reasonable efforts findings. Those findings are part of the process now, but certainly the impression in reading this report is that they could be given more attention, both by the judiciary and the attorneys involved in the process, the parties involved. And again, in a recent meeting, I think it was before the Justice for Children Task Force, we were talking about this report in all of the different aspects of it. And again, Marshall was talking about the idea that if we had more training, had more, I don't want to say pay attention, because we do have to make reasonable efforts, findings now, but we could use them in ways that I don't think they're being used now. And the idea is that if these reasonable efforts findings were made in more detailed attention there, it may change how we conduct the termination of parental rights hearings if the cases lead to that point. By that, I mean, if you have detailed findings on reasonable efforts, you may be able to consider those findings as part of the TPR and therefore not have to devote as much time to a TPR because you've already made, hopefully, appropriate findings along the way. So that's again why I think it's important to hear from both the state and the Defender General's office on this report. I will tell you that reasonable efforts is something that the court takes seriously. At our judicial college, I want to say it was 2 years ago, we had a retired judge, Judge Edwards from California, who is nationally recognized as an expert in this area, came to the judicial college to speak to us. And we have the opportunity now in early November to send 5 judges to, when I say send, I Zoom 5 judges to a day-and-a-half session of reasonable efforts. So the recommendations, the ideas in this report, I think have been taken very seriously by the parties involved. I think we can use it to build on the original idea behind Chen's reform. What can we do to improve the system, which has now, of course, been impacted by the pandemic? And I will say, and I've said it before, if there is a silver lining in the pandemic from the judiciary perspective, it's the increased use of technology and the ability to conduct remote hearings. I was on a meeting earlier this week with juvenile judges from all around the country, and I can tell you that their response, their reaction has been the same. They've all increased the level of remote hearings in their proceedings. And I think almost universally, we're saying, regardless of when this pandemic ends, there will always be a use for continued use of remote hearings in many parts of the juvenile docket. We have found, and this point was echoed by some of the other judges in this meeting, that we've actually increased participation of some parties and their ability to connect. Because it eliminates transportation issues, it sometimes eliminates the need for childcare so that they can participate in these proceedings. And again, the report has a section in here that talks about increased use of remote hearings. And I would hope that we can build on that and continue to take advantage of the technology that has been developed over and introduced over the last year and a half. And made a difference in many of these proceedings. And I would just—
Can I ask a question about the technology?
Sure.
Is there a plan to interface with our social service technology so there's more direct link with folks, or does your software separate, or does it link in with? Can it link in with family service workers, for example? I'm just trying to put things together from our previous conversation.
You know, I don't know.
Okay,
I will,
Yeah.
I don't believe so, but I don't want to say that without confirming it one way or another.
yeah, it's always problematic for me when I hear, for example, one hospital has one system and the workers out in the field have a different system, and how can we bring all of this together?
The system that we, of course, now have in place provides for electronic filing. So in the sense that
Yeah,
whatever is being filed through or from a DCF will come in to our system in electronic form. And so in that sense, we can obviously communicate back and forth. And I'm not sure that answers your question, but I can look further into that. I don't believe that they talk to each other, if that's the right phrase.
well, it's hard too, because so much of the information would need to be held confidential, at least for a period of time, and it makes it difficult, but there might be a pathway for some of the information to flow from, especially in the CHINS cases where state government is directly involved, so.
Right. That's really an overview from my perspective on what this report, the highlights, if you will, of this report. As I said earlier, I think it touches on every aspect of the CHINS process. And I was certainly encouraged, even though there are obviously a number of things in there they say where the judiciary can improve, but I think it took a real snapshot of the process. It took it during a difficult time. As you can see from the report, a lot of it was done during the pandemic. That may have impacted the number of people who were involved in these focus groups, but I think even that information was important. It's obviously to a great extent anecdotal, but I think it rounds out the report. So again, those are my thoughts. I would encourage you to hear from Commissioner Brown and the other members of the CHINS reform. I'll be glad to answer any questions the committee has.
So yes, thank you. And Commissioner Brown was not available today, and your suggestion about having Marshall Paul in is also an excellent one. So we'll work to do that. I think we're interested in which of the recommendations, you have phase 1 and phase 2 recommendations, and which ones can be prioritized, which ones can depend on current staffing, and which ones might need additional resources. So this is our this group's, I think, first look at the CHINS report. I know some of us have seen it before, but it will be helpful going forward. Go ahead.
Yeah, I believe it is the first time it's been discussed, other than it was presented and discussed recently with the Justice for Children Task Force. I think in terms of priorities, and have in mind, I think it was stated earlier by one of the committee members about the need to work collaboratively. And I would tell this committee, and I think it'll be echoed by the other folks involved in CHINS reform, that's the process that we've worked. That's how we've worked in this group. We didn't always agree on every little bit, and I think, but what we did was we worked together to put forth what we thought were good ideas, good approaches that should be looked at to see if there's a way of improving the process of these cases. I say that because I think one of the big issues that you can see from the report involves representation, attorney representation, both for parents and children. And I would expect that Marshall would, and the Defender General's office would have their own thoughts on that. But I think it's an area that needs to be explored. As I said earlier, it has been a recommendation in at least 2 other reports over the years that I'm familiar with, that made similar recommendations, but I'm not aware of any action that was taken. I think the legislation that's before the House and Senate now provide a vehicle to take it to the next step and say, well, what does it really mean to look at other ways of handling legal representation? Or is the system that we have sufficient, but maybe needs to make some improvements to the existing system? I think those bills have the potential to explore that issue. From my perspective, I think it's one that needs to be explored further. And I would encourage the committee in that direction. The reasonable efforts is something that's part of the process now, but I think I'm encouraged. One part of the report talks about not only judges getting that training, but maybe what we should be looking at is a joint training with Defender General's office and the state's attorneys involved in this process, so that we all come to a better understanding of how those hearings could be a vehicle towards improving the system. Obviously the increased use of technology, I think, is important. We're doing that now, and the mediation piece. We already have the legislature's approval on that. We're moving ahead there. All the reports I'm hearing from the judicial master, and again, they're anecdotally, but both from DCF that has been working with the judicial master in Chittenden and Franklin counties, the attorneys involved, both from the state's perspective and the defense side, have given high marks to the work that's being done up there. And I think that role, that position has certainly filled the expectations I had for it, and hopefully making a difference. We don't have the data to demonstrate at this point the difference that position has made, having in mind that the position was filled really in the heart of the pandemic, where we had restricted hearings. So hopefully there will be enough time to gather more data that will support what a difference that position has made in helping move the docket. That position has also been instrumental in the first family treatment court in Vermont in a long time, up in Chittenden County. That was a long time in coming forward, but they've started this past March. And I believe they're now involved with, I want to say, 5 or 6 families. And again, the anecdotal reports I'm hearing are that they've made a difference, certainly in those cases, in the parents' response to the additional, I'll call it additional attention that comes with a treatment court approach. So that has been successful. And so I think, a lot of what we have proposed to the legislature, been adopted, put into play, has been successful from my perspective, and from others.
This is really a pleasure to hear, because I know how hard everyone has worked on this, and now there's some outcomes that we can point to. It's terrific, and thank you for all of your work on this. It's just amazing. And I see Senator Sears has come back into view, and he's worked very hard on this and been a leader.
Just to be clear, I was here through the whole thing and just realized my video was off.
I wanted to make sure people know how much leadership you have taken in this area.
Thank
and how
you.
much we truly appreciate it. Right. And so, and I guess the question is, are there plans to take another step with another judicial master in another district, or is that something that's possible at this point?
I don't know if it's possible. Let me say this, the judiciary is just beginning the discussions around their own budget with the for the coming session. I do believe, and I don't want to speak out of turn, but I understand that Department of Children and Families sees the merit in the judicial master position and may have something in their own budget that speaks to adding the resources of another judicial master. I don't pretend to know the details, and maybe that was just talk and it's not part of the budget. But the benefit with the judicial master, as you all know, the judiciary operates under a rotation system. And the judicial master allows us to take a judicial officer, train them specifically, intensely for the types of issues that come into the juvenile docket and share that expertise across counties. And that's where one way we're seeing the benefit of the judicial master in Franklin and Chittenden counties. Since I'm going out the door, I can tell you I would support the expansion of judicial masters, but whether or not this is a year to do that, whether or not the court would include that in their budget, I can't say. But I think at least so far, this position has, as I said, has fulfilled my expectations of what it could do. But I would also reserve hear from the other folks from Marshall and BCF on that. And I would like to see it expanded. I think there's a expanded role for that position, quite frankly, in many of our dockets. But I think it could be has been beneficial in the courts where the master sits.
Thank you. Senator Sears, did you want to add anything? Or
No, not at this time.
All right. Committee, questions for Judge Grierson on the Finn's report, and I think specifically on the recommendations. Any questions? I mean, this is the first opportunity that this committee has actually had to look at this, and I know that the Justice Oversight and Judiciary committees and others are looking at it with an eye to making a change, and we will also look through and see how it fits with any of our recommendations. But we certainly thank you, Judge, for your leadership in this area, and we will take your recommendation of bringing Marshall Paul and Sean Brown in to discuss it further with us, and we'll hope that you're still around when we do that.
Well, number one, include Evan Meenan from the state's attorney's office. He's the fourth leg of this particular stool for his perspective. And I'll be glad to come back if it's helpful to the committee. So.
Thank you very much.
Right.
Any other questions? Representative Pugh.
Judge Grierson, not a question, but just in case something happens and I'm not here for the next meeting, I want to say thank you. Thank you for your work with the Human Services Committee, for your work for children and the court process, and you will be missed. You made a difference.
Thank you. Thank you very much.
All right, I think that's a very good place to move for lunch and say thank you. Thanks for being here.
Yes,
Greatly appreciate it.
It's been my pleasure and honor to have represented the judiciary before the legislature. Thank you.
Thank you. All right, and we'll see you again. So
You will.
all right, terrific. All right, so it